Hey legal studs! In this video, we'll go through the adversary system of trial. For your Saxon exam, you need to be able to define the adversary system. Also, you need to name and explain 5 features of the adversary system and answer the question, how do these features ensure a fair and unbiased trial? Let's start with a definition. The adversary system is the system of trial that we use in Australia. It is based on the idea of 2 parties, also known as adversaries, battling in an arena before an impartial third party, where one adversary will win. The 5 features you need to remember are: 1. The role of the parties. In the adversary system, the parties have full control over proceedings. This means that they are responsible for pre-trial procedures and preparation and presentation of their cases. They gather evidence, organise witnesses, as well as organising the time and place of the hearing. The theory behind the extensive role of the parties is that it allows them to present the best case possible, and if parties can present the best case possible, the trial will be fair and the truth will come out. 2. The role of the judge. The judge's role is to control proceedings, make sure that rules of evidence and procedure are followed, and to decide on the relevant law to be applied. In criminal cases, the judge will decide on the sanction, but will not decide on the verdict, guilty or not guilty, if the trial is held in the county or Supreme Court. In those instances, a jury will decide the verdict. In civil cases, more often than not, the judge decides both the remedy and who to decide in favour of. The judge's impartiality helps ensure that the trial is both fair and unbiased. 3. Rules of evidence and procedure. In the adversary system, these rules are really strict. The aim of keeping them strict is to ensure that the trial is fair and unbiased, and therefore that parties have an equal opportunity to present their case. There are rules, for example, on what types of evidence are admissible and inadmissible. Hearsay evidence and evidence obtained illegally are inadmissible forms of evidence. Rules on procedure include the requirement that a hearing must be single and continuous. 4. The standard and burden of proof. In the adversary system, the standard of proof and burden of proof vary depending on whether it's a criminal or civil trials. In criminal trials, the standard of proof is beyond reasonable doubt, meaning the judge or jury must be substantially certain that the defendant is guilty. In civil trials, the standard is the balance of probabilities, meaning that it is more likely that the defendant infringed on the rights of the plaintiff. The burden of proof in criminal trials is on the prosecution, whereas in civil trials, it rests with the plaintiff. 5. The need for legal representation. Legal representation is pretty vital to the adversary system. A party will be disadvantaged without it. Solicitors handle most of the pre-trial preparation, while a barrister conducts the trial presentation, including questioning of witnesses. Lawyers understand the complex rules of evidence and procedure, and the rules of law, which allows the party's case to be presented in the best possible manner. That's the content, and it is pretty vital to remember, but you also need to practice applying it to the questions. In the 2012 exam, students got this 4-mark question. Every person in Victoria can be confident that, if he or she should face trial in Victoria, the trial will be conducted with impartiality, fairness, and independence. Referring to the above statement, explain 2 features of the adversary system of trial. Here, you need to pick out 2 features and do exactly what we've just done. Explain them well and apply them to one of the elements of an effective legal system: the entitlement to a fair and unbiased trial. Thanks for watching and happy studying!